Welcome to the Cresco Wealthcast. My name is Dimitri Korolis. I'm the host of the pod, and I'm also an advisor within the Cresco Wealth Management team. Just want to say a quick thank you to all of you that continue to support and follow the channel. I appreciate you, and of course, welcome back. And if this is your first time to the podcast, thanks for stopping by, and I hope you enjoy. At the Cresco Wealthcast, the inspiration was very simple. I wanted to bring topics that were derived from real conversations, and I wanted to do it in a way that was relevant and relatable to you. And a lot of the conversations and the content that you're going to hear, it's coming from clients, it's family, it's friends, it's just being out and about and having those real conversations. Nonetheless, I hope you enjoy, but before I let you go, just want to let you know you can find us on LinkedIn, Facebook, Instagram, and YouTube. Just search at Cresco Wealth Management. Until then, enjoy the pod. Oh, and by the way, that music you're hearing, that's Pete Ems. He's one half of Small Town DJs, and it was nominated for a Juno Award. He's on the team. No big deal. All right, excited to be welcoming back a previous guest. Now we're in the friend territory. I like this, but it's the owner and founder of ABA Family Lawyers. It's Abram Averbach. Thank you so much for coming back. It was long overdue. You're busy because you're doing your own thing, which is really exciting. Why don't you spend a couple minutes actually, because there's a little bit of a change in your world of where we were last time we were talking and the exciting stuff going on in the business today.
Sure, and thanks guys. Thanks so much for having me back. It's really a pleasure. It's a lot of changes in my professional life. We opened up ABA Family Lawyers in March of this year, and we're fully operational and off to the races, and looking for just great ways to be delivering family law services to our clients in a smaller, a really more dedicated and focused environment. So far the firm has just been a great change for me, great change for our team, and a great change for our clients as well. So thanks again for having me back.
Yeah, well, congratulations, and of course wishing you all the success, which I no doubt will come. Joining us as well today, Senior Financial Planner Wayne De Boer, and we wanted to bring you back in because the first time that we had the conversation, there was a lot of content. We talked about family law, we did an overview, and this time around, we wanted to say, okay, we got some great feedback. The podcast was a success, and let's start diving a little bit deeper. And then as we were chatting, Wayne, you came up with a brilliant idea to have Abram talk to us about not just family law and divorce, but what that means also for private corporations and addressing questions and maybe potential concerns from our audience as well as our clientele. So Wayne, I'll transfer it over to you. Maybe you can kind of give some insight on this and kick things off.
Yeah, thanks, Dimitri. It's good to be back here too. So where this comes from is our last conversation was mostly around things like family law agreements and how we can protect things like gifts, inheritances, property when we come together, things like that. But when we left that conversation, we started chatting in the hallway and started talking about specifically what that means for businesses, business families, those who have professional corporations, who have just wealth built up inside corporations. It kind of seems like a different experience, a different set of considerations, worthy of its own dedicated conversation. So that's kind of where we are today. So to set the stage, I guess I just want our listeners to imagine that, maybe they built a business over a 15 or 20 year period. They had their good times, they had their bad times, their hard times. And then one of life's, maybe unexpected events comes up and you're looking at a relationship breakdown, a divorce. What happens in this situation? And that's a question that comes up often in our world. So to address it, that's where, Abram, we're bringing you back. And so I guess I want to kick things off and on this topic and just ask about businesses. Like, are they treated the same as property when it comes to any other type of property someone might have in a breakdown, whether it's their house, their RRSPs, maybe a taxable brokerage account? Is it the same? Is it different? How is that looked at in family law?
Yeah, and thanks, Wayne. So a business is going to be looked at entirely the same way as other property on marriage breakdown. who owns the shares of the business is not always the most important. It does depend on when the business was started. On the one hand, when you've got a business that was started before the relationship, you may have a portion of that value exempt from division. Similarly to someone bringing in an investment account into the relationship, or a home that they own before the relationship. Value acquired during the relationship is going to be divisible, and property acquired during the relationship will be divisible. So where you have a business that is wholly started during the relationship, that's going to be entirely divisible, irrespective of whether one or both spouses have a shareholding interest directly in the business. So, being the good lawyer I am, I've answered your short question very lengthily. The answer is yes. Businesses will be treated under the exact same set of circumstances and considerations as any other type of family property.
And so you were talking about whether it makes a difference, whether it was acquired before or during, or who owns it. Maybe it's spouse one, maybe it's spouse two. Is there any special treatment given when family trusts own a business? Because sometimes we'll see that, where someone goes through an estate freeze or a business reorganization, and maybe they don't even own shares themselves anymore, and they put them inside of a family trust. Does that impact things?
It may. Again, being the lawyer that I am, I'll give
Good
you
lawyer.
Yeah.
a wiggle.
Okay.
Yes,
It
Not
depends.
just a.
I want to make sure I give myself enough wiggle room to say I didn't say that. It may. Family trusts are almost a unique set of considerations, and so if you have a family trust where the spouses that are separating are, one of them is a beneficiary, how that trust has interacted with the lifestyle of the spouses starts to become really important. If there is that beneficial interest, but the family trust has never distributed, well, that beneficial interest may have not supported the standard of living of the spouses who are separating, and divisibility of that interest, spousal support considerations may all be mitigated because it's there. But it's that contingent interest, it's that interest that has never really come down the pike. Where you have a family trust, let's say owning the shares of the business, that is now distributing with regularity, with predictability, maybe the family trust owns other assets that are used by the spouses, that's where you start now getting into a scenario where the family trust is at risk of attack from the non-beneficiary spouse, because it has been used to really benefit the family's life prior to separation. So it's sort of, you could think of it as it's been brought into play in terms of the day-to-day of the family. So context really matters when it comes to family trust and that sort of ownership, where there is direct shareholding interest at the separating spouse level. We now have family property. Where there is the beneficial interest, it's a maybe, and it really depends on use.
So you're saying there's some questions to be asked, and for those that are thinking, you know what, we'll just set up a family trust, we're protected, nothing bad could ever happen. There's a couple more questions on the nature of how you want to use that in relation to the business.
That's perhaps the number one most surprising answer that I give to high and higher net worth families, is that the family trust vehicle is not necessarily as protective as anticipated.
Wow. So setting up that family trust, people need to be really made, have an understanding of what they really want to do with it. And if it is a protection standpoint, maybe they need to come talk to you first.
And that's where the bolt-on of a family law agreement, of a prenuptial agreement, of a cohabitation agreement, of a marriage agreement, start to really round out those protections. Because at the time of the creation of the family trust, there might be no intention of the separating spouse to ever attack it. Things can change when things change. And so adding that extra layer of protection, not only does it add the protection, but it adds the flexibility and the freedom for that family trust to do what the settlers of the trust are wanting to do with it, which is support other generations of the family. And so adding some of the language to ensure that those protections are there so that the trust can do what it wants to do without tiptoeing into legal prejudice is a best practice, we'll call it.
Wow. Yeah. Thank you.
And so you sort of led into something there, I think, when we're talking about generations. It seems to me like that type of risk could especially be, prevalent with maybe Gen 2. Like, so if Generation 1, for example, mom and dad started a business, it's owned by the family trust, but they brought in their children as indirect shareholders. Maybe they're involved in the business, and they sort of started, giving their children benefits of the business through that structure because the children are involved in it. Yeah, we sometimes don't think about divorce at that second layer. Sometimes we think of it at Gen 1, that top layer. Mm-hmm. Yeah. But when the child of a business owner is a beneficiary of a trust and they're going through a divorce, there could be some protection that's not actually there.
Well, that's true. And also, at that Gen 1 level is that, because of course we'll see that where there is the freeze and the value is moved out to the family trust. Depending on who the beneficiaries of that family trust are, even at the Gen 1 level, in the event of separation, there is a risk of attack if there is not adequate family law disclosure between the Gen 1 spouses when that trust is set up, such that, let's say, one of the spouses is not a beneficiary to the family trust. Without there being adequate family law disclosure, there is case law that then has that trust and the property of the trust subject to attack from the non-beneficiary spouse at the Gen 1 level.
Okay. In your answer to the last question too, you mentioned about the importance of a prenuptial or a marriage contract, family law agreement. When we start looking at some of these legal considerations around owning a business, how do you often see those agreements drafted to account for family, like shares of a family business, whether it's owned directly or indirectly?
We see them often in cohabitation. We see them often in prenuptial agreements. So this is the circumstance where you've got somebody coming into a relationship or bringing into a relationship an existing asset, an existing business that blood, sweat, and tears have already been put into. And so we will often see at that stage the business interest being carved out from something that would be divisible, being called separate property in those agreements. And so we'll look at this and we'll say, okay, business XYZ is acknowledged as having a value of X. It's understood that this value may increase over time. The business itself and any increases in value to the business are going to be called that owner's separate property in the event of separation. We see it less frequently in the context of a marriage agreement, an agreement about property made after the fact, because at some point in time, those businesses have started during the relationship. They're just seen different. They're seen differently because they weren't created solely through the effort of one of the parties before the relationship even existed. But oftentimes we will carve out the divisibility of existing businesses from these types of agreements.
So you talked about talking about the disclosing the value there. I mean, that kind of brings me to a whole different set of questions here. Is really around like, how do we come to those values? Like, I mean, I've been through corporate reorganizations with clients, business sales, different types of events where we bring in, a professional to do that for us. What are some of the methods that you'll typically use in these situations, Abe, to come up with a value of the corporation? Because there's so many different things to consider. There's what you have on, like book values that are showing up in the financials. There's goodwill. There's, growth prospects, maybe big contracts that are, so close to being signed that could greatly impact things. How do those conversations go in your seat between yourself, your client, your client's former spouse, opposing counsel? What do those conversations look like?
Yeah, that's the can of worms right there, right? Because I'd imagine there's a pre and post and during.
Well, that's right. And again, it depends greatly on the nature of the business. Now, and I think your question, Wayne, is really targeting operating entities. But in my world, I'll see all different types of businesses, ranging from a holdco that perhaps has nothing but investments. Mm-hmm. That is a much more straightforward valuation exercise. We're looking at value of the book. We're looking at prospective capital gains. We're looking at, in the event that money is coming out, we're looking at liquidation costs and disposition costs, things like that. If we're looking at a business that's a straightforward number company where an individual is really using that as the vehicle in which they're deriving income, the individual who is a consultant to a company, we normally have a fairly straightforward valuation task there because, as I say to people, nobody is lining up to buy the Abram Averbach Professional Corporation. There's no extra value in that thing. Whatever's there is there. When we've got an operating entity, now we're going to get into a range of valuation concepts of varying complexity depending on the nature of the business. We will often use business valuators, chartered business valuators, to help with that because as a lawyer, we are allergic to math and allergic to numbers. And so we invite the valuators who are the real professionals of this. And their valuation approaches will vary based on the business. It may be a going concern valuation approach where they're considering what's in the pike and what's coming down the pike. It may be simply an asset valuation if really this is an entity that it doesn't have a lot of standalone value besides its assets. It could be a liquidation approach if something is on the track towards wind up. Oftentimes, if we're able to, and depending on the nature of the business, sometimes the most helpful will be what's happened recently. Maybe there's been a sale of some interest in that business within the last 6 or 12 months where a fair market value has been assigned to the per share value. That might be then a way, while not going all the way to a formal valuation, where we can feel confident that we've got an objective value being set. Maybe there's been, maybe that company has been out looking for some seed money recently, and so they've put a valuation forward. Maybe that valuation isn't the valuation that the owners of the company want because that investment document's a little bit more of a pitch document than it is a real hard concrete statement of value. So there's a real range there, but we will frequently engage business valuators to help us with the right approach, whether it's 3 turns on EBITDA, whether it's 5 turns in this industry. I've worked with startups before, which is a remarkably interesting valuation approach because the balance sheet of a startup is typically not responsive to what its actual value is or maybe in the future. And so retaining the right third-party professional to take a look at a trend analysis on the financials and assess the value that way is a real asset to the family lawyers in that case.
At what point does someone not have claim? I think you touched on it a bit in your answer there, is things will change within the business. So you have the event where you have to bring in a family lawyer. You're going through all those proceedings. You evaluate the business at a particular time. What stops someone from maybe hiding something off the books, shelving it, thinking, oh, don't proceed on this, we'll wait till things are done? At what point does someone have a claim on a look back?
It's a really good question, and it's going to be very fact specific. We are always valuing family property as of today. We're not a data separation valuation province.
Right.
So we're always looking at it today, but today is still informed by yesterday from the standpoint that where we've got a lengthier time since separation, perhaps we've got some significant changes in the business, up or down. That may affect the divisibility number, what that number is that's being divided. unquestionably, you may find a business owner who is, perhaps unquestionably is not right. You may find a business owner who is looking to delay the progression of something out of a concern that the business may experience a significant uptick in value.
Yeah.
You've got a proving issue there if you're on the other side of it to establish that has been delayed. Where you've also got a proof issue to establish what would have happened had that not been delayed, because it is relatively hypothetical. Perhaps what you're doing, especially with private companies, because one of the things that we certainly know is that the private company will have a value. Actually putting your hands on that value outside of the private company is oftentimes exceedingly difficult. A business that has a value of $20 million as a private business, oftentimes the only way to get that $20 million out is to burn the business down and to liquidate it all. And so with some creativity, especially where we've got successful businesses that are perhaps, more nascent or have a lot of productive days ahead of them, sometimes what we're doing is we're keeping both parties engaged on the ride, so to speak, so that both share in the upside, the future upside of the company. And that's where some creativity can really help us, because sure, there's $20 million there. Well, 10 cannot come out. But here's the way where you share in that 20 turning into 40. And from the business owner perspective, perhaps that equalization payment on day one is mitigated in exchange for the sale of some of the future upside in the business. That's where some of the creativity comes in the negotiation of resolutions here, where we can really find something that can work. And it's particularly difficult in tightly held private companies, because your marketplace for sale is constrained generally. Maybe it's constrained by shareholders agreements, which I know we're going to talk about later.
Yeah.
But so finding a way where we can leverage some of the future, because it's exactly that. So perhaps the spouse who is lesser involved in the actual business has a lot of faith in it, and is looking at things and saying, this thing's going to go pop as soon as I'm out. He or she knows it. He or she is dragging their feet on it, and they're just waiting, and this thing's going to go from 2 to 22 million as soon as I'm out of the picture. So how do I protect myself that way? And the more involved spouse is going to be saying, but I hope so, but there's no reason to think that's going to happen. So where you intersect is sometimes by tying the parties together. And then you've got considerations about what do those shareholding interests mean from the lesser involved spouse in terms of voting shares, in terms of any operational say. And so it's just bases that need to be covered off with some flexibility and creativity.
Let's jump into that actually while it's hot, because you're saying it about shareholders agreements, shares. Can the agreement itself prevent the share transfer? Or maybe I'll give it to you that way as a blanket question and maybe go in, because we're really tying it right in to what you were just saying. What actually prevents, and what are the things that we need to know about a USA or unanimous shareholders agreement?
Yeah, because where I see a unanimous shareholders agreement really dovetailing with this is when we talk about a separation of property, we're sort of dealing with, a marriage relationship over here, but each individual of that relationship lives their own life. So, in a family, a husband or a wife, they're connected to each other, but the wife may have signed on to another agreement somewhere else that now is impacting the husband. So yeah, I guess that's really where the question comes, is how do these other agreements, and it might be its own episode, but how do these other agreements come to influence these situations?
Well, you guys have great coffee here, so I'm always looking for a reason to talk my way into another episode.
Which we will, by the way.
I think the first place to start with answering that is understanding what the family property interest entails. Because, and this is typically a kind of a day one fear point of the business owner. So the business owner, let's say, owns 100% of the issued and outstanding shares in the operating company. Now they're separating. And the concern is now my spouse, who perhaps has had some, perhaps has had absolutely no involvement in this business, now entitled to 50% of my shares in the business. And it's not exactly that. The family property interest of that spouse is to 50% of the value. It's not necessarily 50% of the shares. For all kinds of reasons, a court is not going to grant the spouse half of the shares in the operating company, where now the separating spouses are the two directors of the entity. That sounds like a great way to go from some value to no value in a whole bunch of conflict, and nobody works out better there. So the family property interest of that spouse is really in the value of the shares that are held by the other spouse. Now, shareholders' agreements are almost always recommended, and they're quite powerful in a number of different ways. The answer is that yes, most shareholder agreements will prevent dispositions of shares. There might be a right of first refusal that goes to if we're presuming there are two equal shareholders, the shareholder agreement may prevent dispositions before giving a right of first refusal to that other shareholder. The shareholder agreement will almost always include a trigger clause of separation. Now, that is often, in my experience, not leveraged. When you have a healthy business partnership between the shareholders of the company and one of them is going through a separation, it's rare to see that provision being leveraged by the existing shareholders to trigger a buy-sell. But it's there. It's always there.
Is it? Yeah, and why do you think that is? That's a good point. It sounds like it's, the way you're saying it is such a formidable tool. Why is it getting overlooked in your experience?
Business harmony. And so
okay.
The three shareholders of the business see one of their partners, their fourth partner, is going through a separation, but they say, well, that person is an integral cog of the leadership of this business. Yes, it's unfortunate that person is going through a separation with their spouse, but I'm confident that they're going to be able to keep their professional life intact. I'm confident that they're going to continue to be able to be making responsible and productive business decisions, and we don't want that person out. We are less as three than we are as four, and so that's a big reason. The protection is there for the fear of the third party, or that separating spouse's shares being acquired, and now all of a sudden you've got five shareholders. That's why that triggering provision is there. But generally speaking, when you have a harmonious business before a separation, typically your business partners aren't looking to then get you out. But it's a triggering event. It certainly can be relied upon.
Yeah, I've sometimes heard of USA's shareholders agreements just being referred to as like a fight book of last resort. Like, it's you want to have it because if for some reason you have a disagreement or an event that you can't work past, you've pre-agreed to the rules, but you try to avoid that as much as you can, because if the business is harmonious, if it is profitable, if it's functioning, why wreck a good thing? So,
and a USA may also include valuation provisions. That may be, that's one of the first
that's
places
where I was going to go
look.
with this too, is going back to the previous with the valuation. How much bearing does that stand on valuations? We're on the same page on that.
If I'm advising, I think the first question I'm advising somebody when there is a USA that includes some of that valuation language, I'm looking at that with them and I'm saying, where are we on the Goldilocks scale here? Are we too hot? Are we too cold? Or are we just right? And if, depending where you stand always depends on where you sit. And so depending where we are, if that number, if that valuation from the USA is too low, then we're going to argue, well, that was a private agreement between the shareholders of the company to facilitate buy-sell. And that ought not to be the only way that value is examined. If we think it's too high, I suppose we're saying the exact same thing. And we're wanting to have a third-party valuator take a look. But if that valuation provision looks like it works for both spouses in the separation, it can absolutely be the way that we value the interest in the company.
Is there any merit to discount clauses from a family lawyer's perspective when it comes to things like, separation, buyout due to separation? Because, I imagine from what I'm hearing from you so far, Abe, it's all about, is it reasonable? But sometimes we might see, a buyout at, I don't know, let's say 80% of fair market value in the event of one of these unexpected events, like whether it's death, disability, divorce, you name it. Because sometimes companies just don't have liquidity to fund those buyouts. So but I also hear your argument that, maybe it's a private agreement on the side designed to dissuade something. So in your seat, how do you approach those types of things?
Well, fire sale is never a great way to be looking at fair market value, but we are almost always incorporating, in the case of private entities, we are with real frequency looking at different discounts on the price, whether it's a minority discount. Perhaps the shareholdings in the company are 49%. 49% shareholding is a whole lot less marketable than 51% because you don't have board control in that circumstance. Perhaps the USA may adjust the 49-51 reality at the board level. Also liquidity. It's a whole lot easier to sell your shares in Apple, sell your shares in any publicly traded company than it is to shop your interest in a private entity. So your pool of potential buyers is just smaller. So we're frequently discounting. If the value is $1 million, perhaps we're putting a 4 to 6% minority discount on it. Perhaps it's steeper. Perhaps we're putting that liquidity discount on it because it's just a harder thing to market. But the my feet were held to the fire and I needed to come up with some money is perhaps the least persuasive, I think, from my perspective, of the valuation discount concepts.
Yeah, and I want to tee you up on something here because, the tone of what we're talking about is from the standpoint of, what, something has happened, here's how we look at it. And I'm sure that makes up a lot of your business and your practice. But let's go back. What should people be coming to you about the things you could do preemptively with all the things we talked about today? To say, listen, just because it's family law, maybe some people have a stigma and the connotation of it only means one thing. But looking at all of these things, when should they be coming to you and what can you do to set up the structures?
Yeah, great question. And I have a lot of conversations with business owners who are entering perhaps the second relationship. Perhaps it's the first, and we've got young business owners who are creating something really special. And it's something that they're looking to be protected. Perhaps it's a business owner who has sold an interest. Oftentimes what we're then doing, and this is the right time to be having those conversations, is as that relationship is really gaining its strength, you want to have those open conversations and just say, look, the reality here is that there are things that I am bringing into this relationship from a property perspective that I think concepts of fairness suggest are mine in the event that this relationship between us doesn't end the way that we're both anticipating it to end, which is happy. If it doesn't, these things that I'm bringing in, I put a lot of my energy into this. I've created something here, and I want to protect that. And where we start having these interesting conversations at the agreement level is figuring out how fairness works for both of the parties with those considerations in mind. Because perhaps someone's coming in with a business, and a home. Well, maybe fairness says the business is going to be protected, but the home, even though it could be protected at law, won't be. That's the trade-off, and that's how everyone can feel secure in the arrangements. Where there is a business that is started, where we've got a long-term marriage, 25-year marriage, and over the course of that marriage, a business has been created, that cake is a little bit in the oven when it comes to a reality on separation. But where there's those existing assets coming into these, new or not so new, but meaningful relationships, we can do a lot with protections and with flexibility. And we have the conversations I was just talking about. We have conversations about how the value of the business might be shared between the parties by intention. Perhaps there's an understanding that some assets of the business or some of the value of or the income of the business is going to be used to purchase things that benefit the family. And so we can account for those things. And it serves as a launching point for a whole raft of fairness discussions, and having those discussions, particularly when a couple has pre-existing assets, having those fairness discussions at the front end. You're dragging me back to the first podcast with you guys, but having those discussions at the first end and deciding what is fair when everybody is the best version of themselves, when everybody has their highest form of respect for the other, when everybody is looking at this through long-term successful eyes, that's the time when fairness is really meets the definition of the word, I think, from my perspective.
No, that's great. And we joked about it earlier. You said it. There's so much content. We're bringing you back for another one, and that is true. For today's podcast, or I should say for this one right now, we're going to stop at this point in time because we want to be fair for the remainder of the content and split it up in 2 different episodes. So stay tuned because we are going to upload both episodes probably a week apart. But Wayne, you wanted to tackle some things like income determinations, disclosures, some of the other items that you had on the bill you wanted to ask Abe as well.
Yeah, I would like to address that because I think that what we've done here today really is just kind of the first piece of the puzzle, so to speak. And so let's figure out how practically on like a financial basis these types of things work themselves out. So I'm looking forward to that conversation next. Okay, well, appreciate it. And yeah, we'll be kicking it off here pretty soon. Hope you enjoyed the episode, everyone. Thanks for stopping by. Please feel free to leave your comments, or even if you want to let me know topics that you think I should be talking about. You can find us on LinkedIn, Facebook, Instagram, and YouTube. Just search @Cresco Wealth Management. And last but not least, if you want to be up to date with our newsletters, our insights, and even our events that we host throughout the year, you can reach out to me directly. It's pretty simple. You can just go to our website, find me from there, crescowealthmanagement.com. Thanks again, everyone.